All right, good morning, everyone. I put a little keynote presentation together to kind of cover this. Marla, can you confirm that you can see the first slide?
Yes, I can see it.
All right. So I guess we can have people just type questions in the chat box, Marla, and you can feel
Yes, they
free.
can they can use the Q&A button that is located on their screen. And once we get to your question and answer portion, we'll read them and you can go from there.
All right, good deal. All right, so I'll get started by saying I believe in discovery. When it comes to discovery, on the plaintiff side, our goal is to play offense, not just be reactive and play defense. This entire presentation is about how to handle discovery in a personal injury case, and I'll give you guys several examples. So in all of our cases, we believe you should have a discovery notebook. In the discovery notebook, we start off with a plan and case track, the issues we want to address, and how we want to go about doing that. The case overview is kind of where we perform an analysis of the case to determine the strength and weakness of our case as well as the other side's case. And we have forms and templates that we've kind of built out to address all of this. Next, we cover the jury instructions or rules. I'm going to talk more about that in detail, but we sincerely believe that at the beginning of every case, you should research the applicable jury instructions and other rules. The bulletproof in the plaintiff portion is a comprehensive approach we take to preparing all of our clients for deposition. It's either one full day or 2 or 3 partial days that we spend with clients prior to the deposition. The question and answer section of the discovery notebook is checklists that we use depending on the type of witness. We have a checklist for the plaintiff, checklist for the defendant, checklist for the police officer. There's the medical experts. We have checklists for those people as well. And we always take the checklist and make some case-specific additions or deletions to the checklist. The deposition scheduling section is just everything we do to get the deposition scheduled, from calls or emails to the other side to the deposition notices. And the database is where we collect everything, pleadings, discovery, responses, discovery we send out. We store all of that in the database section of our discovery notebook. Exhibit list and exhibits are, we keep a running list of exhibits, and whatever exhibits are used, whether they're used in deposition or we anticipate using them, we add those to the exhibit list. And when the case gets close to trial, we can take this exhibit list and these exhibits and duplicate them and move them to our trial notebook. Deposition rules, I'm going to give you guys some specific examples of that. I believe it's important to know the rules that apply to depositions. I remember when I first started doing depositions, I'd walk in and they'd say usual steps, and I'd say, sure, usual steps, not even knowing what it means. But more importantly, at this point, I think it's important to know what the rules are, what are valid objections, what are not valid objections, because most cases now, or the depositions are trial. If you're going to resolve a case, it's going to largely depend on how you perform and the client performs in depositions. Notes and summaries is just where we capture our notes or summaries following any deposition. Kind of helps us wrap our head around whether or not we made the points we wanted to make and what do we need to do moving forward. Originals is just where we store the original deposition, things to do or things we need to do and follow up on. And focus groups, or if we do any focus groups in-house or remotely, we want to be able to see what the focus groups like or don't like in our case, or what they need or don't need, and incorporate that into the case moving forward. Marla. John said he's having trouble getting on to the link.
Yeah, it's saying unable to attend because host previously removed you or something like that.
All right, you're gonna have to email her. All right, so let's dive into the investigation portion of it. In-house investigation. What do you need to do? I believe it's important that you interview the client, take time the first day and talk to the client, but you also need to have subsequent interviews with the client to gather additional information. Oftentimes the client is just unable to give you everything you need on the first visit. So it's important to have repeat visits with the client. Interview the client, interview witnesses, request official reports. This could be a police report. This could be an incident report if it's a slip and fall at a store. We always want to request the official reports. Send preservation letters if it's a case where you believe the car might be destroyed, the camera video might be deleted. You want to send them a preservation letter early on. That way, if they do destroy these things, you can raise a spoliation claim. It's important to visit the scene of the crash and use Google. I remember when we started practicing, we always had to go to the scene of every crash. Now, with Google Images, it really alleviates the need to visit every scene, but it's important, I believe, to pull the scene up. And if there's anything unique, you need to get out there. And obviously, if it's a premise liability case, you need to get to the scene. So what do we include on our client interview sheet? When we're interviewing the client, it's important to get all the background information, the facts concerning the incident, as much information as the client has on the defendant. You want the client's work history, educational background. You want the client's criminal record. If there's any prior claims, there's a database. It's called ISO Claim Search. You can actually pay a fee, I believe it's $75, and they will provide you with a report of all of the client's prior claims that were made with insurance companies. You want the client's insurance information. It's important to know if your client has no insurance or uninsured motorist or MedPay or any other coverage that's relevant. And you also want the client's health insurance information. You want the client's medical history. And then we always give clients homework, things to do, for example, we give them a typical Facebook warning, things to be aware of when it comes to posting on social media. The homework could include bringing additional documents to us at a later date that they usually don't have on the first visit, as well as keeping a log or running journal of the issues that they are having as a result of their injuries. So we do this client info sheet that you're looking at. We cover this early on at intake. We try to capture all of this information, and then we follow up with respect to anything that's unavailable to us at the initial meeting. So subsequent to that, we do a 90-day follow-up with the client. So I know the title is Discovery, and people may say, what does this have to do with discovery? I believe before you dive into doing tons of discovery concerning the defendants and spending money, it's important to kind of figure out what kind of case do you have? What's the value of the case? You need to discover the value of your case. So what we do is this 90 days general damage follow-up. And if we look at the 4 headings I have at top, I want to find, as the client talks about these things, I want the client to identify a witness other than themselves who can testify as to this. I want to know the last time they were able to participate in the activity. I want to know how often they would participate in the activity prior to the crash or injury compared to now. And I want to know the effect that the either being unable to do the activity or a diminished ability to do the activity, how that affects them in their day-to-day lives. So we cover all of these areas. We cover sports, hobbies, social activities, work around the house, activities with kids, personal activities, financial. And with respect to each one of these, I asked the client, tell me some people, family members or friends who can talk to, who did you play sports with? When was the last time y'all played sports together? When y'all would play sports, how often would y'all play? Not being able to play this sport or only being able to play it half the time compared to the way you did before, how does that affect you daily? And we cover this with each and every one of these activities. And the reason we do it 90 days out is because majority of the times people are fine, and by that 90-day mark, a lot of people are back to their normal selves or recovering, so that the adverse effects on their lives are minimum. But if we hit this 90-day mark and they have any ongoing issues, then we know the case is potentially going to be significant. We believe it's important to capture this. The other thing we cover is a TBI checklist, which stands for traumatic brain injury. I believe that traumatic brain injuries are much more prevalent than people believe. There's research that shows that clients suffer traumatic brain injuries is missed by the emergency room doctors 56% of the time. And if a client has a TBI, you automatically have a six-figure case. So I believe it's very important to do a pre-treatment TBI checklist, and we like to do these 2 weeks out, and I'll tell you guys why. 5 or more points automatically prompts a 90-day follow-up for a TBI. The reason you want to do it 2 weeks out, because if a person hits their head, there's some initial swelling and initial cognitive issues that might resolve. So we really want to wait the 2 weeks before we do this, and somebody can just call the client on the phone 2 weeks post-accident and ask these questions. So if we look at the symptoms that are in front of us, you get 1 point for every one of these. If you hit your head, there's gaps in memory, headaches, forgetfulness, and you need five or more points to generate a 90-day follow-up. If a person has a concussion, then by definition, a concussion is a mild traumatic brain injury. The person has a TBI if they suffer a concussion. This form is not my form, it's not my creation. I went to a CLE in Vegas, and this was the treatment protocol developed by the Brain Injury Association of California. So we've been incorporating this into all of our cases where it's relevant and for the last few years now. So let's assume now that the client has 5 or more points. We go to the 90-day follow-up. And we have a detailed form where we discuss all of these issues in detail. Obviously, if they're significant issues, the client needs to be sent to a neurologist to be evaluated for a traumatic brain injury if it hasn't been done by any medical professional up to this point. So now I want to move and talk about, now that we've kind of covered discovering the extent of our client's injuries, because I believe that's very important. I want to talk about the witnesses. What should we do with lay witnesses, family members, friends, or witnesses to the incident? So when it comes to working with witnesses, I believe it's important to let the witness know how he or she fits into the case. Oftentimes, people will say, well, I just saw the wreck. I don't know why it's important for me to be there, or I wasn't there. I'm just his friend. Why? I don't understand what I have to do with this. It's important to let them know if it's a witness to the crash, you can explain to them what liability means and how more than one person having the same version is beneficial. When it comes to family member or friends, you can let them know how it's important for them to talk about how the injuries have affected the client on a day-to-day basis, because they're going to know that better than any lawyer or doctor or anybody who doesn't, see the person on a daily basis. I like to ask the witnesses what stands out most in your mind about the incident, about the injuries, and just kind of let them elaborate without asking a leading question. Because if I ask a leading question, I'm probably going to cut off a nugget that this person can really provide for me. Another question I like to ask them is, what is your biggest fear or concern for your family member or friend? And that'll give you a good deal of what they're really worried about with respect to the injuries. And then I always ask for specific examples of things they used to do and cannot do, or things they used to do, can still do them, but now at a diminished level. And I like to get the lay witnesses to elaborate on that. Spend more than one session with the witnesses. Obviously, we generally do this every day, so we're comfortable doing it. But the people we represent, as well as their family members and friends, they have anxiety when it comes to talking to lawyers. So it's important to meet with them more than once and meet with them at different locations. I'll meet with them at their house. I'll meet with them at a coffee house. I'll go have lunch with them at a place they like to eat, and then we'll just talk. And oftentimes you get much better information than you do just marshaling the people into your office to ask them questions. All right, so let's talk about case rules. Case rules are the jury instructions, statutes, regulations, manuals. The manuals, driving manuals, employee manuals, and case law. So every case, I believe the jury instructions and the case rules are the roadmap to get you to the finish line. So my law clerks, I always have them starting here. We pull the jury instructions with driving manuals or the case law, and we come up with a list that's specific for whatever case we're dealing with. And I'm going to give you guys examples of how to put it all together. So if we were doing a rear end collision, we would start by developing an annotated working list of rules. For an example, a driver should leave enough distance between himself and the car ahead so that he can safely stop if the car ahead suddenly stops. I'm going to play some examples in a deposition of how I would use this rule to get the defendant locked down when it comes to liability. Here's an example from a pedestrian case. A driver must use more than ordinary care to see what is ahead when approaching a pedestrian crosswalk or an intersection. And then every motorist has a duty to avoid colliding with any pedestrian upon any roadway, and has a duty to give warning by sounding the horn when necessary. So you would use this by asking the defendant, would you agree that you have a duty to avoid colliding with pedestrians? Would you agree? And then obviously so whenever you're developing these rules, the rule has to be simple, and it has to make sense, and the defendant has to look foolish if he says no. So if I were to ask a defendant, would you agree that you have a duty to avoid colliding with a pedestrian? The only answer is yes. If he says no, that's still a great answer, because that's just a foolish answer. And your rules have to be that simple to where they have to agree with him or they look foolish by denying it. Here's another example. A driver must not try to squeeze into a gap that is too small. Straight from the Louisiana driver's manual. If a person denies that, then they're in trouble. Another example from the Louisiana driver's manual. So using these rules in depositions. So I take the annotated working list of rules with the law because I need that for my reference, but I'm not asking the witnesses in their depots about the law. So when it's time for a deposition, I want to simplify these statements, and the statements you see, the 4 statements you see on the screen are examples of questions I would ask in a deposition. A driver must pay attention to the speed of the vehicle he is following. And I ask, do you agree or disagree? If they agree, I have them check and initial next to agree. And then I ask them some follow-up questions to lock them into the answer. And I'm going to play some video clips of examples of me doing that. And here's a couple of rules from an actual case where I had the witness circle and then I attached them as exhibits. So written discovery. So what to do and when it comes to discovery to the other side. Now that you've interviewed your clients, hopefully you've talked to witnesses and you have did a preliminary search for the rules, the jury instructions, case law, statutes and regulations that apply. Another great source of rules is going to be policy and procedure manuals of the defendants, but that's something you usually don't get until written discovery. So the way we like to do it, I don't file the written discovery with the petition. It's probably because I'm cheap, but almost every case the defense lawyer calls and asks for an extension. As soon as he calls our office asking for an extension, I send him a copy of the written discovery to his client as well as the insured. The discovery of, and then after we get the responses to the written discovery, we begin scheduling depositions of parties. With respect to non-parties, you can start taking those depositions as soon as possible. There's no need to wait on written discovery responses. Motions to compel. If the discovery is not answered timely, you need to set your 10.1 conference as soon as the time delay expires, and you need to have the at the 10.1 conference, the defendants like to say, "Oh, I need some more time. Can you give me some more time to get those answers?" I never accept that. I need a definitive date. I don't care if they say 15 days or 30 days. Just whatever it is, give me a date. Give me a time, a number that I can put on my calendar. If you don't have your discovery by then, you need to be following your motions to compel. We, on the plaintiff side, we only get paid when the case is resolved. So if you allow them to drag it out, they'll drag it out. So I believe it's important to get this written discovery over ASAP, follow up with your depositions, and file your motions to compel if you have to. So let's talk about depositions, because I believe when it comes to discovery, it all leads up to getting the depositions and being effective in those depositions. So obviously in depositions, there are usual steps, not steps, steps for stipulations, rules and case law. You wanna know what's important. So we actually have I actually have another keynote, which is a bunch of slides that I bring to me with depositions showing what objections are proper, what's improper. I'm going to give you guys the summaries, but an example of what we have is what the actual case law is held with the citation. So let me go through with you an example of some of the rules that apply to depositions. Attorney must conduct themselves at depositions in the same manner as they would at trial. So obviously, this is the case law. There's case sites that support this. So if I'm in a deposition and the other side's getting out of hand, I will read this to them with the case site, and I'll attach it as an exhibit. And usually if you do that a couple of times, they stop doing inappropriate things. If not, you'll have a huge record of improper objections or behavior that you can now take to the judge. So what's correctable objections are waived for trial if not raised at the deposition. So objections to the manner, the oath, misconduct, evidentiary issues, or the form of the question. These are the objections you have to make at the deposition. And this deals with speaking objections that lawyers routinely make. Deposition objections must be concise, non-argumentative, and non-suggestive. And I have the cases that cite that I'll include and attach as an exhibit to the deposition. Non-correctable objections are preserved for trial and should not be raised at deposition. Relevance. Defendants routinely raise relevance as an objection at a deposition. Relevance is an improper objection at a deposition. And so is beyond the scope, so is hearsay. And so when they make these objections, you either call them out on it or you ignore it and keep going. Witness coaching and speaking objections are prohibited at the deposition. Oftentimes, you ask a question and the other side will say, you can answer if you know. The case law is clear. If a lawyer telling his witness to answer if you know is considered coaching. And I cite the case, I attach it, and if it keeps happening, then I can file a motion for sanctions for continuously violating the rules. Objections to vagueness. Objections due to an attorney's lack of understanding are prohibited. So routinely you'll ask a question and lawyers say, objection, I don't understand the question. I'll look directly to the witness and say, sir, ma'am, did you understand the question? And if the witness says yes, just ask them to answer it. Now, obviously, if the question is confusing, you need to rephrase it. But if you know you asked a perfectly fine question, just ask the witness to answer and keep moving. Lawyers attempting to reinterpret or rephrasing your question is prohibited. So if you ask a question and the lawyer on the other side tries to chime in and say, what I think he's asking you is this, and then he proceeds to ask a question, do not allow that to happen. You would be giving up control of your deposition. B is improper. Now he's asking questions. It may not even be remotely similar to what you intended to ask. All right, there are only 3 proper instances to instruct a deponent not to answer. 1 is to preserve a privilege. 2 is to adhere to a court-ordered discovery limitation. And 3 is to suspend the deposition and move for a protective order. And you're going to see one of the examples I'm going to play for y'all, the lawyers hooping and hollering, and he asked to go off the record. When we go off the record, he didn't want to get the judge on the phone, so we went right back on the record, and I continued asking my questions. And you'll see that in the clip I'll play later. But it's important to know if somebody tells the witness not to answer, if it's not one of these 3 reasons, you need to make them know that's not proper. Either the witness is going to answer, or I'm going to have to file a motion, and we'll have to come back another day and redo this, and I'm going to ask for sanctions. Usually that'll open their eyes, and they'll instruct the witness to answer the question. All right, just more rules. A lawyer is absolutely prohibited from coaching his client. It talks about when asserting a privilege, you must make a record. They can't just say objection, attorney-client privilege. They have to make a record of the subject matter surrounding how the privilege was created. For instance, if they say, this is a conversation my client and I had in the office, then it may be privileged. But if it say, hey, it was me, my client, and the other unrelated driver, we all met, and this is the discussion. If that's the case, then there's no privilege. So it's important that if a defendant raises a privilege, you need to explore the subject matter of that privilege without going into the actual facts. And here's the Louisiana rule. Most of the case law is federal cases. So all those summary slides that I've showed you guys, I have additional slides that I could do a whole presentation on just that. I have additional slides with the case law and the case sites. This is what Louisiana, the Supreme Court has said. Since we obtained these discovery rules from the federal rules, we may look for guidance from the federal decisions, which have been interpreted, identical provisions. So most of the law is found in the federal cases, but this case here allows us to apply it to our depositions in Louisiana State Court. All right. These are just rules straight from the Louisiana Code of Civil Procedure. I won't go through those in detail. And I'll share these slides. If anybody wants them, Marla, we can figure out how to, I'll email them to you, and you, this whole presentation, you can send it out to people. So next I want to, the earliest thing I talked about is the rules and visiting the scene of the crash. So this is an actual case I'm working on. This is a Google image I pulled off. I pulled off the internet, and my theory of liability is that the defendant ignored 3 warning signs. There's the stop sign, there's a do not enter sign further out, and there's the no left turn sign. And the animation you saw is an animation I actually created in Keynote based on the facts that my client gave me as to how the accident happened. And the 2 vehicles you saw, I just copied images of the actual vehicles the parties were driving. I pulled them on Google Images and I dropped them in there. And I created a little animation that I can use in depositions for sure, and maybe even at trial if it's accepted by the judge. So here's an example of a deposition where the lawyer objected that the lawyer's objection is, I don't understand the question. Say it again. And here my response is, the question is to her, the witness. Do you understand the question? The witness says, yes. Okay, you can answer it. And now, so why do I do that? If I repeat, first of all, I don't believe there's anything wrong with my question, number one. Number two, if I repeat my question at the defense lawyer's request, now I'm giving her control. So as long as this witness heard my question, understood my question, there's no reason for me to repeat it. And as you can see, that I did not. With respect to depositions, I believe it's important to get in and get out. A lot of the prep work is done early on to really narrow the focus of your case, but that doesn't mean you have to take 5-hour depositions. The example I'm about to show you of a get in, get out is approximately 1 page of questions. And now granted, when I walked into this deposition, I had my checklist. I thought I would probably take about an hour to depose the witness, but his demeanor when he came in, his attitude towards my client, made me feel like I could probably get in and out really quickly. So a strategy I like to try early on in every deposition is ask the witness the hard stuff early. Give them a chance to admit fault, and if they don't, then I'll go back and ask all the stuff I need to ask. So with this gentleman, I asked him, before we go into a long spiel, as we sit here today, is it fair to say that you were responsible for the accident? His response is yes. Is it fair to say that, to your knowledge, my client wasn't doing anything wrong? He says yes. Now his lawyer's objecting, but objecting to the form of the questions. There's nothing wrong with the form of the question, so I'm just ignoring those objections. And at the time of the wreck, she was following all traffic rules and regulations. He says as far as he knows. And I said, she was, as far as you know, she was, yes. And so it's a 1-page deposition. I take this, I'll file a motion for summary judgment. Amazingly, they opposed it, and I didn't even get to argue. The judge took over the argument for me and granted the motion for summary judgment on liability and course and scope, I believe it was. So I'll say all that to say, when you can, get in and get out. There's no reason to drag it out if you don't have to. So now I want to give you some examples of putting all the rules together. The witness I'm going to, the clip of the witness I'm going to play is a commercial vehicle driver in a crash where 2 commercial vehicles crashed. So I started early on with the rules, and then I got my written discovery where I was able to pull his training manuals, the policy and procedure manuals. So you're gonna get an idea of me taking the rules, putting it all together, and then I'm also gonna have some headlines where you can see some of the concepts that are put into play, and you can ask me about those concepts later. But these are concepts we try to use in every case to get to where we're trying to go and maintain control. So let's start with the first one. Covers rules, and I'll just let it play. Would you agree that a driver approaching a stop sign at an intersection should come to a complete stop, observe traffic, and only proceed when it is safe to do so?
Yes.
I want to hand you a form, and we'll call it Exhibit 2, and I want you to circle the answer you just gave.
It's repetitive.
Can you circle the answer you just gave? We'll call that Exhibit 2. Now, is that important that a driver do that?
Mm-hmm. Yes, sir.
Tell me why it's important.
To protect the safety of others.
What else?
That's all I can come up with right now.
Would you agree that it's important that a driver follow that rule because it's the law?
Yes.
Do you expect others to follow that rule while driving on the roadways?
Yes.
Why do you expect other drivers to follow that rule?
For the safety of others and the law.
Would you agree that if a person doesn't follow that rule, that person is a dangerous driver?
Yes.
Would you agree that a person that doesn't follow that rule is a reckless driver?
Objection. Form the question argumentative.
You can answer.
Yes.
Can a person who ignores the rule that requires them to stop at a stop sign at an intersection and come to a complete stop and observe traffic and only proceed when it's safe to do so, can a person who ignores that rule injure someone?
Objection. Form the question argumentative. Compound.
Yes.
Can a person who ignores that rule kill someone?
Same objection.
Yes.
Would you agree that a driver should never run a stop sign?
We'll stipulate to that. Yes.
Yes.
If you're going to answer questions, I'm going to have to put you under oath.
No.
I'll hand you.
No. I'm not going to have him circle agree to that. If we need be, we'll take a recess.
Let's take a recess.
Let's take a recess. You get the
Going
judge
off the record at 11:09 a.m. We're back on the record at 11:10 a.m.
All right, Mr. Clay, I want to move on to the next question. Would you agree that before starting across a road, the driver of a commercial vehicle must make sure he can get all the way across before traffic reaches him?
Objection to form the question.
You can answer.
You go ahead and respond if you can.
Yes.
I'll hand it to you, and I want you to circle your answer for me. I'm gonna attach that as exhibit number 3.
I want you to read the question first, and then he wants you to circle the appropriate answer if you can.
And you circled agree, correct?
Yes, sir.
Yes, sir.
Is it important that a driver follow that rule?
Yes, sir.
Why is it important?
To save the lives of others and the law.
Can you think of any other reasons why it might be important?
Safety.
It's important for the safety of the public in general, correct?
Yes.
It's also important for your safety, isn't it?
Yes.
Do you expect other drivers of commercial vehicles to follow that rule?
Yes.
Why do you expect them to follow it?
It's the law.
In your opinion, if a person fails to follow that rule, is that person creating a danger on the highways?
Yes.
Would you consider that person to be a reckless driver?
Objection. Form the question argumentative.
You can answer it.
Yes.
You knew this rule existed at the time of the accident, correct?
Yes.
And you violated it anyway.
I'm not gonna answer.
You have to answer
Why?
because you're required by law to answer.
Well, you have to answer it if you can give an answer.
I don't think I'm a bad driver.
I didn't ask you if you were a bad driver or not. I asked you if you knew this rule existed and chose to violate it anyway on January 18, 2015.
I did stop to the stop sign and I did stop to the railroad track. I stopped at both of them.
Did you make it safely across the highway before the collision with Mr. Garrett?
No.
How many vehicles passed?
Too many, can't count.
Was it more than 20?
Oh yeah.
More than 100?
No.
More than 50?
No.
So somewhere less than 50, but more than 20, is that fair to say?
Mhm.
Yes?
Yes.
And then are you a safer driver now than you were back then?
I think so.
And did those videos contribute to you being a safer driver now than you were back then?
I think so.
And did you watch any similar videos while employed with Stronco?
No.
And is it fair to say that number 5 of the defensive driving code says defensive driving requires a thorough knowledge of the rules of right-of-way and the willingness to yield right-of-way to other drivers to avoid an accident? You read that in this policy, didn't you?
Yes.
And by reading in the policy, you mean just a moment ago?
Just a moment ago. You read this in the policy.
Yes.
And you had this policy was given to you during your employment at Stronco, correct?
I would know.
As an employee and driver for Stronco, were you required to abide by the provisions of this policy?
Yes.
And it's your testimony today that you never knew this defensive driving code existed?
Objection to form the question. He never said that.
Is it your testimony that you never knew about the defensive driving code in Stronco's policy?
No.
Why not?
Maybe it was overlooked.
Was it overlooked by you or was it overlooked by the person who was responsible for making sure you had a copy of the policy.
Is that policy being attached as an exhibit?
Just
Just don't keep it out, please.
No,
no, what? That wasn't the question. The question was not a yes or no question. It was the defensive driving code overlooked by you, or was it overlooked by the person in Stracco who was responsible for giving you the policy?
Objection to form of question. I don't understand what's being asked.
Do you understand the question, Mr. Clay?
no,
Upon being hired by Stracco, the drivers are given a driver handbook, correct?
no,
You do sign a form saying you were given a driver's handbook, correct?
yeah,
And you did sign that form, didn't you?
yeah,
So are you saying you signed the form, however, they never gave you the policy?
yes,
Thank you. I want to attach this as a Mr. Clay, earlier you testified that immediate prior to this collision, you did not have the right of way, correct?
right.
Mr. Garrett, in fact, had the right of way, correct?
That's what the state trooper told me.
As far as you know, being a driver licensed to drive on the streets of Louisiana, were you required to yield the right of way to Mr. Garrett?
Yes,
No. And is it fair to say that you didn't yield the right of way to him on this date, correct? Is that fair to say?
I stopped, not yield.
Did you yield to Mr. Garrett, yes or no?
I stopped.
You stopped prior to the railroad tracks. Is that what you're saying?
I stopped prior to the railroad tracks, and then I stopped again at the stop sign over the railroad track.
I understand all of that. My question is, did you yield to Mr. Garrett?
No,
Now, your lawyer came up with this statement. He had you circle exhibit number 6. It says, did Mr. Garrett in part cause the accident? Now, I thought we had this cleared up, but I want you to tell me all the facts that you have available to you that will lead you to believe Mr. Garrett contributed to this accident. You don't have any. Is that what you said?
yes, sir.
Do you have any witnesses that could say that Mr. Garrett, in part, caused the accident?
No, sir.
Do you have any documents that you could point to or that you have seen that would show that Mr. Garrett, in part, caused the accident?
No, sir.
So why did you say he, in part, caused the accident? Was it just to agree with your attorney?
No, sir.
Why did you say it?
Because I thought he was going to let me turn, being that we was at this intersection together. He couldn't make the turn, so I thought he was going to let me turn.
So you made an assumption. Is that fair to say?
Yeah,
And your assumption ignored state and federal law that requires you to yield the right of way, correct?
Objection to form of question.
You can answer it.
they just put that stop sign there at that intersection. If that stop sign wasn't there on January 18th,
I appreciate all that. But my question
he
is,
wouldn't have a ticket to give me. He wouldn't have a ticket to give me. The only way he gave me a ticket because of that stop sign.
does your assumption that Mr. Garrett was going to let you go, even though he had the right of way,
being that he was
Allow,
Right.
does your assumption allow you to ignore state and federal law that requires you to yield the right of way? That's all I have. All right, that's it. That is all I have. I'm available for any questions that anybody may have.
If anyone has any questions, you can either type it in the chat, or if you want to use the Q&A button on the screen.
I see Sharon asks if I always video your depots. If it's a significant case, six-figure value or more, I always video the depots. If it's a small case, less than 100, I may or may not video the depots. But the importance, this witness, that case settled like 2 weeks after his deposition. So aside from the answers he was given, if you would look at his demeanor, you could tell that there was something going on. That's why I kind of was pressing him with some of my questions, because I was there looking at him and I felt like there was something going on behind the answers that he was giving. And so, yeah, I think it's important, if it's a witness that you want the jury to be able to perceive their what they were like giving testimony, you record it. And if the case has significant value, you want to take video. It's much better to impeach them with a clip of their video depo than it is to read a transcript.
We have a question from Kay Gilbert. If I object and the judge is not in, who is responsible for paying the reporter to come back another day?
The judge will probably have to decide that.
And Sharon had a follow-up. She said, I had a car like that, and we settled 2 weeks after because of the body language of their client. This was really good, Chris. Harry has a question. He has his hand raised. Let me allow him to speak.
Oh, that was a mistake.
Oh, okay.
I'm gonna say he's right down the hall.
Okay. Okay. So I disabled him speaking. Anybody else have a question for Attorney Christopher Washington? All right. Okay, Kay Gilbert, if my objection is valid, I don't think I should have to pay. Oh, well, that was a comment.
Well, I agree. I agree with that. So let me briefly, some of the concepts I think is important for everybody to, obviously I talked a lot about the rules. Exhaustion is just when you ask the witness about the rule, you don't just get them to agree. Do you agree that a driver should leave enough distance between himself and the vehicle he's following so he can safely stop if the vehicle ahead suddenly stops? The answer is yes, but that's not good enough. You want to elaborate. You always want to say, do you agree that it's important? Why is it important? And you want them to give you reasons why it's important. If they don't, then you give reasons and get them to agree with it. And then I always like to ask them, if a driver ignored their rule, is that person careless? Would that person be considered reckless? And then in one instance, you knew this rule, and if you don't do this in every situation, but you say you knew this rule existed and you chose to ignore it anyway. And you word it like that because you always want to present it as if the other person made a conscious decision, like not you failed to follow the law. That's a mistake. You want to say you chose to ignore it anyway. You knew this driver had the right of way and you chose to ignore it anyway. And that in the mind of the jury, he's taking an active step to violate the law, and that's why this incident happened. The other concept, obviously, as you can see, the lawyers make baseless objections, ignore them. At one point in time, in the clip, he asked me if the exhibit was being attached. It doesn't even matter if it's attached or not, but his attempt was to throw me off the question, and the witness responded saying no, but it wasn't even a yes or no question. So you got to be careful. A lot of times they'll do things that try to throw you off that has nothing to do with what's really going on. It's really to try to stop you from making the point you're making. Bracketing is very important. I use bracketing all the time when it comes to distance, time. So I'll say in a rear end collision, I'll say, how long had you been traveling behind the plaintiff before the wreck happened? And they may say, I don't know. So you start with extremes, would you? And so you would say, were you traveling behind them for at least an hour? And it's like, no, not an hour. Was it at least 30 minutes? No, it was less than 30 minutes. How about 10 minutes? Well, it was less than 10 minutes. Was it more than 5 minutes? And then they'll either say, if they say yeah, then you got them in a bracket. So somewhere between 5 and 10 minutes, you were traveling behind this vehicle before the collision. So you do that. You can do that with time. You can do it with distance. You can do it with anything where they give you evasive answers and they can't commit to a number or an estimate. You create a bracket and you lock them into a bracket. And also the other thing I showed you guys in the FWD, that stands for facts, witnesses, and documents. Whenever they make these baseless defenses that the plaintiff caused the wreck, or the plaintiff, a lot of times it's medical, the plaintiff failed to mitigate their damages. I'll ask them, I'll say, can you give me all the facts that you have that support your position that the plaintiff did not go to all her medical visits as ordered by her doctors? Are there any witnesses you can point to? Have you seen any documents, medical records, or any other documents that would say the plaintiff failed to mitigate her damages? And I do that with all the defenses: liability, causation, and damages. I'll exhaust their defense, because truly, if they have no support for a defense, they're not supposed to be raising it. So if you kill it in the depot, then the defense is dead, and the case goes to trial. You don't have to deal with it, and usually the case will settle, though. I
We have a question from T. Varnado. How often do you introduce the statements with circled answers that you attach to the deposition at trial?
Opening statement. I take, usually it's 2, no more than 3 of those statements. I'll use them in my opening statement at trial, unless the judge says no. But I haven't had a judge say no. It's the law. The witness, it's the law, and the witness agreed to it. I haven't had a judge say no.
Any other questions? Okay, Sharon said that was her question. Okay, I want to thank Attorney Christopher Washington for coming in and sharing his knowledge with us. And also, I again want to apologize for the mix-up because the wrong Zoom link was put on the platform.